I'm asked whether creditors get the opportunity to vote for or against an insolvency process, and the answer to that question is it really depends on which insolvency process you are talking about. In the case of bankruptcy and compulsory liquidation, where a creditor petitions the court for a bankruptcy order against an individual or a winding up order against a company, this is a process which is court-led, and it will be the court which, on the petition of a particular creditor, decides whether a bankruptcy order or winding up order is made. And at the same time that a bankruptcy order and a winding up order is made, then initially the official receiver, who is a civil servant, would be appointed either the trustee of the bankruptcy estate or the liquidator of the company in compulsory liquidation. Hence, at that stage, the general body of creditors does not have a say as to who the trustee or the liquidator is. However, in voluntary liquidations, more particularly voluntary liquidations where the company is insolvent, there is a requirement in statute to call meetings of both the shareholders of the company in order that the shareholders pass the necessary resolutions of the company to wind up the company in accordance with the Companies Act, but also a meeting of creditors which will receive details of the history of the company and the causes of its failure, and also what is known as a statement of affairs detailing the assets and liabilities of the company. And it's at that creditors meeting that creditors will have their opportunity to either confirm the shareholders' choice of the liquidator or to potentially appoint their own choice as insolvency practitioner. They will also get the opportunity at that meeting to raise any issues with the directors that they wish to pursue. In voluntary arrangements, whether individual voluntary arrangements or company voluntary arrangements, again, there will be an initial meeting of creditors to consider the individuals or company's proposals, and the creditors there as a body will have the opportunity to vote on those proposals, to perhaps seek modifications to those proposals in order to give their acceptance, and to generally, again, discuss the affairs of the individual or the company concerned. They also have the final say in who will act as the supervisor of the voluntary arrangement. In administrations, it's commonly the case that the insolvency practitioner acting as administrator will either have been appointed initially as a result of perhaps a resolution of the directors or as a result of an application to the court. However, this does not mean that the creditors are entirely excluded from the process, in that the insolvency practitioner is required to thereafter subsequently call a meeting of the creditors to seek their approval of the proposals for the future of the company, whether that be trading in administration or the realisation of the assets, and indeed the payment of fees to the administrator. So at that point, the creditors will have the opportunity to vote in favour or against those proposals.